The Railway Labor Act, RLA, is a federal law that applies to the railroad and airline industries in the United States. The RLA was enacted in 1926 and was amended several times since then, most recently in 1978. The purpose of the RLA is to promote the stability of the railroad and airline industries by establishing a framework for the resolution of labor disputes, and to encourage collective bargaining and the peaceful settlement of disputes between labor and management. The RLA applies to all carriers and their employees engaged in interstate or foreign commerce, including airlines, railroads, and bus companies. It covers a wide range of employees, including pilots, flight attendants, mechanics, and other workers involved in the operation of the carriers. The RLA does not apply to employees of the federal government, state and local governments, or private sector companies that are not engaged in interstate or foreign commerce. The RLA establishes a number of rights and protections for employees in the railroad and airline industries. It guarantees the right of employees to form and join unions, and to bargain collectively with their employers over the terms and conditions of their employment. The RLA also prohibits employers from interfering with the rights of their employees to form and join unions, and from discriminating against employees for their union activities. The RLA sets out a specific process for unionization and collective bargaining in the railroad and airline industries. Under the RLA, employees who wish to form a union must first gather support from at least 35% of their coworkers. Once they have sufficient support, they can file a petition with the National Mediation Board, NMB, a federal agency that oversees the process of unionization and collective bargaining in these industries. The NMB will then schedule an election to determine whether the majority of employees want to be represented by a union. If the majority of employees vote in favor of unionization, the union and the employer are required to negotiate a collective bargaining agreement, which sets out the terms and conditions of employment for the employees. The RLA also includes provisions for the resolution of labor disputes. If the union and the employer are unable to reach an agreement during the collective bargaining process, either party may request the assistance of the NMB to mediate the dispute. If the parties are still unable to reach an agreement, either party may request the NMB to release them from mediation and allow them to engage in self-help, such as strikes or lockouts. In cases where the parties are unable to resolve their disputes through collective bargaining or self-help, the RLA provides for the use of arbitration to resolve the dispute. The RLA also includes provisions for the protection of the public during labor disputes. If a dispute threatens to disrupt the operation of a carrier, the NMB has the authority to issue a cooling-off order, which temporarily prohibits the parties from engaging in self-help for a specified period of time. The NMB may also appoint a Presidential Emergency Board, PEB, to investigate the dispute and make recommendations for its resolution. If the parties are unable to reach an agreement after the PEB has issued its recommendations, the President may appoint an arbitrator to resolve the dispute. The RLA is an important piece of legislation that plays a crucial role in promoting the stability of the railroad and airline industries and in protecting the rights of employees in these industries. We rely on the support of our viewers to help us continue our work, and we would be grateful if you would consider subscribing to our channel. By subscribing, you can help us reach a wider audience and ensure that we can continue to produce high-quality content. Thank you for your support, and we hope you enjoy our videos.